Good evening, friends. Amongst us, we have Justice Paramjeet Singh Dhaliwal, a former judge of Punjab and Haryana High Court, and he has also been the former president of Punjab State Consumer Redressal Forum. He has been taking sessions on the channel of Beyond Law CLC on various perspectives of law. And today's session is quite fascinating, as the topic suggests: partition of immovable properties, agricultural and non-agricultural. The session will be divided into two parts. Primarily, it will be focused in English, but since he's from Punjab, we keep on getting requests. At the end of the session, we will have a brief synoptic note, or we say a brief synopsis of what he said in Punjabi. So those who want to stay connected in both the parts, they can. But we will be having question and answers in this session. It's a short session. Do stay connected with us. And we are thank you to Justice Dhaliwal for always accepting our invite. He's also a designated senior, and he's primarily practicing in Punjab and in the Supreme Court of India. Over to you, sir. Thank you.
Yes. Good evening to all of you. Specifically, Mr. Vikas, for giving me an opportunity to participate in this discussion on the partition of movable and immovable properties. We have been off and on generally talking of partition of the agriculture land. Firstly, let me start with the non-agriculture land. So far as the agriculture lands are concerned, which are assessed to land revenue, the partition is governed by the state laws. In Punjab, Haryana and Himachal, this is governed by the Punjab Land Revenue Act. So far as the non-agricultural lands are concerned, they are governed by the Partition Act of 1893. This is a very small act, and there are only 10 sections of this act which are relevant for this purpose. When we talk of how do we distinguish whether it is agricultural or a non-agricultural? There are possibilities when the non-agricultures are also used as agriculture, but they are not assessed to land revenue. We may talk the Abadi and Rudi also in the villages and the other lands which are not cultivated. They are lying there as it is. When we talk of the urban cities or semi-urban cities, where such like as construction of shops, commercial complexes and others, then dispute arises, then what is to be done? So far as the non-agricultural properties are concerned, they are partitioned by way of a civil suit. A civil suit is filed for partition and separate possession. In the civil court, when you are filing a civil suit, then you will have to show your ownership and the rights for that. It is divided into two parts. When ultimately suit concludes, then two things happen. First is the preliminary decree, as defined in the CPC. Section 2, subsection 2, their decrees are defined. In fact, preliminary decree is not defined anywhere, but the reference has been made there. Then there is a final decree. What is preliminary decree so far as the partition of by way of civil suit is concerned? That is only the determination of the right and share of the person who is filing an suit, that is the plaintiff. The rights are determined by the preliminary decree, and appeal also lies against the preliminary decree to the higher courts, even up to Supreme Court. So far as the final, once the preliminary decree becomes final, then it is to be partitioned in real sense, meets and bounds, which we say after examining the rights of the parties, to the share of the parties, and how this happens. That is, in fact, the final decree is the execution Now the Supreme Court has said that it is the duty of the courts itself that once the preliminary becomes final, then they should suo moto continue for final decree and partition the lands by appointing a local commissioner, maybe an advocate, maybe a revenue official or any other person, which court may find suitable for that purpose. Then he will examine it. There are situations which we will have to look into. Where the court finds, suppose there is a shop, its area is only 9 into 10, 9 feet into 10 feet, and there are 5 shareholders. What will be the possibility? 9 feet into 10 feet. In any manner, firstly, we will have to look into the situation where the passage goes, where is the street there, whether it is on the length where the side is 10 feet, whether it is on the 9 feet. 5 person, if it is on 10 feet, then 2 feet each, and 9 feet, 2 into 9. If it is on 9 feet, how this property will be divided into 5? It will be less than a feet. Now, less than a 2 feet. In that situation, then section 2 of the Act, Partition Act, defines that the court can find it, then court can sell it and distribute the proceeds of the sale. Or there is a possibility where the shareholders can take it and purchase it by fixing a reserve price as per the market value. Thereafter, the auction is given. Whosoever give the more prop, then that it can also be done. This situation, then there may be other situations also. During the pendency of proceedings, there may be a death of some of the parties, some of the shareholders. Now, that is specifically with reference to the preliminary decree. Then there is a provision, then there is no limit that how many numbers of preliminary decree can be passed. That can also be passed by the court in accordance with the situation branch. This is the one thing. Another thing we have considered, where the shareholders are, then option can be given to the shareholder also. It can be put to auctions also. The question which we generally face is the prolonged litigation, and earlier the situation was that the execution by way of the final decree was unduly delayed. Many questions may arise also, whether after the passing of a preliminary decree, principle of limitation act will apply. The Supreme Court has already said in many of the judgments that when the preliminary decree is passed, rights are determined, it has become final, and ultimately the property is to be divided or sold, whatever the situation may. In that circumstances, what you will have to do is to see that no limitation applies to the final decree for the purpose of execution. This reference can be made to the judgment AIR 1967, Supreme Court 147. Then there is another limitation, the judgment is there, that is the Shubkaran Bhuvna versus Sita Saran Bhuvna, 2009, volume 9, Supreme Court 1470. Then the latest judgment which says that it is the suo moto duty of the civil courts is the Kattukandi versus Kattukandi, CA number 640-66407 of 2010, decided on 13th of June 2022. Kattukandi Ethel Krishnan versus Kattukandi Wilson. This is the latest judgment where the Supreme Court has said that it is the bounden duty of the court where preliminary decree has become final and all the rights have been determined, then the court can look into this. There may be a possibility of fraud. Everybody knows if there is a fraud in obtaining the preliminary decree, that can always be challenged, even in the execution proceedings. That is the settled law. So this is a very short and crisp, and we can discuss the question. Mr. Vikas, we should now, this is not much, only there are 10 sections. Relevance I have already told you. Any order passed will are deemed to be deemed decrees under this case once the final partition is done. That is the section 8 of the Partition Act specifically states. We have finished this the non-agricultural properties. We may ask if anyone want to ask the question, we can discuss that.
Sir, if any question will come, it will come. Let's complete it. Everybody knows in our session we take it at the end of the list.
Okay. I may refer to the judgments which may be important in this regard. Specifically, I will repeat the judgment. One is Phulchand versus Gopal Lal, AIR 1967, Supreme Court 1470. Regarding preliminary decrees. Then the actual determination is in the final. Then you can make a reference to the judgment of Shubkaran Bubna B Bar Bombay UBNA versus Sita San Bubna 2009 volume 9 SCC 1470. Then the latest judgment where the issue of limitation and others has also been dealt with. That is Kattukandi Edethil versus Krishnan versus Kattukandi Edethil versus Wilson. CA number 6406647 of 2010, decided on 13th June 2022. Where the Supreme Court has said once the preliminary decree becomes final, that is the duty of the court to suo moto execute it by way of final decree. Actually, partition should be done. Then there is another judgment is very important. That is Satnam Singh versus Surinder Kaur. That is CA number 700A of 2008, decided on 2nd of December 2008. Then another judgment is Medinini Koteshwar Rao versus Medini Bhaskar Rao, CA number 3233 of 2009, decided on 5th of May 2009. These are the important judgments under this subject. Then you can, where in judgment they have referred the number of preliminary decrees can be passed, limitation, suo moto power of the court after the finalization of the preliminary decree and actual execution. Then you can make reference to the section 2, empower the court to order sale if their division is not possible. Then there is under section 3, procedure is prescribed where the sharer, co-sharer want to buy the land. Then that procedure is also given. Section 4 talks of the suit by the transferee in a dwelling units. That can also be taken care. Then there is a section 6 which says that bidding by the co-share the reserve price of the bidding is also to be taken care. Procedure has been prescribed. Where the property to be sold, Section 7 gives the procedure for the sale of the properties. Section 8 of the Act finds that the orders for sale to be deemed as decrease. That has also been defined. Others are the saving clause where the partly partition, partly sold situation arise. Partly partition and partly sold also arises the issue. Suppose when there are 4 or 5 shareholders, 2 are having their own share, that share is given to them. The rest of the share that is sold and this is merged with the total property of those person holder. These are the situation where these things we will have to look into. Now we start with this agriculture lands. First of all, the agriculture land in Punjab, Haryana and Himachal Pradesh is governed by the Punjab Land Revenue Act 1887, where the new name has also been given by Himachal Pradesh Revenue, but the provision substantially remains the same because only name of the states have been changed. Even the Haryana has changed the name of Haryana Land Revenue Act, but the procedure and the methods are the same. The relevant sections are almost the same with slight variations and amendment by the respective states. Now the question is how to proceed. At the very initial stage, I may clarify, the power has been conferred of assistant collector first grade on the tehsildars and naib tehsildars. People say that the partition is done by the naib tehsildar or tehsildar. This is a layman language. As a layman, we can say that. But since you are filing an application, you are an advocate and maybe person filing itself in person, then the situation is, then you must list assistant collector first grade who is empowered and the authorization has been given by specific notification to the naib tehsildar and tehsildar to do the partition. All the applications which are agriculture land, one thing very material is which you must note that they must be assessed to land revenue. Then the question is also there where the properties are kept for the reserved for the rudis and abadis. They are the Garmamkan properties. If they are separable from the land in question, then they cannot be partitioned under the Punjab Land Revenue Act because they are not agricultural land. So now the question comes, what is to be done? First of all, you will have to show your rights. What is your right? What is your share? How you will determine? How you will proceed? Firstly, you will go to the revenue patwari, circle patwari, from where you can get your jamabandi, or you may be having any decree or judgment in your favor. On that basis, you can move an application by filing an application under the provisions of Punjab Land Revenue Act. I will only refer to the Punjab Land Revenue because they are the virtually the same acts. I will refer, it means with respect to the respective states. Then application is filed. You will mention about the properties. Then you will have to state about your rights. The court will examine, that is the AC first grade will examine it and say that you have a share, and then it will issue notice to the other parties who are related, other co-sharers, and as recorded in chapter 4 of the Jamabandi, or which sometimes called Fard also. where their shares have been recorded. Then after the notice, the parties appear. They have a right to file their reply. They will file reply to it. Then sometime question arises. They say that the property has already been partitioned by way of a private partition and has been recorded in the revenue record, or there is some writing regarding that issues are to be defined. They sometimes say that the shares are not correctly recorded and there is a dispute regarding that. Then there are two situations. Court can, AC first grade can close the proceeding there and ask the party to get decided the question of title from the civil court, or AC first grade itself can do it and proceed with it. Then the issue is determined thereafter proceeding. When these issues are decided, when court this AC first grade come to a conclusion that this land is likely to deserve to be partitioned, then he calls Naksha Alf or A or K or Uda, whatever these have reference. Uda and K, they are and Alf, they are the same thing. That is the first Naksha which is called. This mentions the share of the parties, recorded share, actual possession, deficiency and excess. There are a number of columns, quantity and quality, everything is mentioned there. The rights are based on that as per the Jamabandi or the issue determined by the AC first grade with regard to the question of title. On that basis, this is done. When this is done, the parties have a right to look into that and raise objection whether their rights have been correctly, that their share have been correctly determined. So far as the excess or less property is concerned, that is also mentioned in that. That is ultimately to be compensated when actual partition is done, and if any deficiency is, then property is added to the share. If there is no deficiency, excess there, then property is deducted and given to the rightful shareholders, where as per his right share. Then this is the Naksha Alf came. Then statement of the parties is recorded for which is known as mode of partition. How the property is to be partitioned, what share is to be given to whom, which person want to keep their property separated from others, or which want to keep their property together. Sometimes some of the people may be asking that there will be remain joint. We do not want partition. Some says then that there should be partition for any. This statement is recorded where everything is written, in what manner the property is to be concerned, how the water courses and the passages are to be given, what will be the situation where the individual party had installed tubewell, etc., or had made a farmhouse there, and the situation, all these situations are specifically mentioned in the mode of partition. If their parties are aggrieved by the mode of partition, they can go file an appeal before the collector, and for the time being, the proceeding may be stayed. Automatic stay is there in such a situation. Now, after the Naksha, this mode of partition, MOD, which is generally called MOD, mode of partition, or we call it as Trika Taksim in the local languages of the states. Thereafter Naksha Bay comes. In Punjab, this is Naksha Ada. In Urdu, they say Naksha Bay. In Hindi, they say Naksha Khay. Khay is called for that purpose, where the party shares are given and the passages are provided. Everything is done as per the existing passages as far as possible. The main method is that the property which is near to the Abadi, that is more costly and proportionately given, which is on the metalled road, that is also given as per the share of the parties. So if there is a acute fragmentation, then the other modes and compensatory method can also be used for that purpose, and that can also be done. Once the Naksha Bay comes, where the separate tax for individual parties or who want separate property are before the parties, then the parties have right to raise objection to that. There may be no passage is not going, or there may be water course is not properly defined there, and their rights are affected. There is no other any type of objection, or the property has been taken out, which is where they have installed or where they have constructed a kotha for tube well, etc. Some construction over the property that has not been given to. In that situation, all the things are taken care, and ultimately when Naksha Bay is formed, if the parties are grieved, and once Naksha Bay is approved, along with that a field book is prepared, in what manner, which property, which side, and the even this khasra numbers, so rectangle number 13, khasra number 12, that is to be partitioned and given to the other party. Then this is mentioned, rectangle number 13, 12 over 1, 12 over 2, 12 over 3, like this, and the separate numbers are assigned to this, and field book is also prepared along with that. Once it becomes final, no appeal, etc. is preferred against them, appeal revision or the writ, whatever it is, as per the stages. Then what is to be done? Then Naksha Jeem, Naksha ED is called, where the separate the existing position before partition and after partition is shown. That Naksha Jeem is called ED, that is prepared, and parties' rights are determined there. If there is an error which is not contrary, which is contrary to the share defined in Naksha Alf, or the not in accordance with the Naksha Bay, which has been approved by the AC first grade, then they can raise objection to that. Otherwise, after 30 days, instrument of partition is prepared, where the time is mentioned that the possession can be delivered after the cutting of crowd, then specify that for particular months this can be done, and this is the end of all this. These are the proceedings. In between, we have a remedy of appeal where you are aggrieved before the collector, then the commissioner, then the financial commissioner, then the writ petition. These are the remedies, again, with regard to if the parties are feeling aggrieved and any other grievance they have. I think everything is covered now. Any question? We can discuss, Mr. Vikas.
Yes, sir. Though on the chat we do not have, but on the YouTube we are having.
If any question I can answer to the best of my ability, knowledge regarding the field. But if hello.
Yes, sir. I'm just checking it out.
Yes.
This is by Sirinath. An HUF consists of husband, wife, and daughter. Matrimonial cases are between husband and wife. The results cannot be predicted. Can Karta husband sell the immovable property?
No, property, that is altogether different laws with regard to the property, selling of the property. He can always sell for the benefits which are genuine, and there should be reasonable cause for that. It can be, Karta can sell the property for treatment, for religious purposes which are necessary to be performed, not for every other things. This his rights are only limited. He cannot sell without any reason the property. He can only sell for limited purposes. When the cause is pious cause and related to the family. Otherwise, he cannot sell the entire property. Yes.
This is Vaibhav Sharma. Sir, with respect to court fees and suit valuation for a non-agricultural land partition, ruling on this point, how this is needs to be calculated for a co-share?
The co-share, when we have to determine, then he will have to assess the value of the property which come to his share, because ultimately the share which is relevant, market value is to be taken into consideration. On that basis, the fee is to be fixed. So far as the agricultural lands are concerned, this is only this negligible and fixed court fees has been fixed by the various states. There the only, if the land is, there are two things which you have to take. Virtually, partition is a declaration in civil suits. Then the fees of whatever is payable on the declaratory rights. And so far as the possession is concerned, if it is assessed to land revenue, then 30 times of the land revenue is for the purpose of jurisdiction and 10 times for the purpose of court fee of that. If this is a city property, then the value of the property, that on that basis, this is to be calculated. He will have to file keeping in view his share, and this is the property and this is my share, which is I'm asking for partition.
This is by, so please elaborate on oral partition on a non-agricultural property for self-acquired property. If this oral partition is penned down by way of notarized document, which is not registered, is it binding on all parties?
There is not, this is not a compulsory registrable document. That you will have, you must register the partition. Partition can be oral, but it must be oral by some time become difficult to prove. Then there must be, if the, at some stage the family has partitioned the property, then they can write the memorandum of partition that this has happened earlier and the parties are authenticating that. In that situation, they can use that and prove that this land has already been partitioned and it was a joint property at one stage and has been partitioned by metes and bounds.
This is self-acquired property of father. After his death, 4 sons want to divide the property. How can the self-acquired property be partitioned?
Self-acquired property, what is the nature of the property? Is it a agriculture or non-agriculture?
Agriculture.
Agriculture. When this property is a agriculture property, then firstly they will have to show that this property, there is a no will and the rights are of all the co-sharers, which are governed by class 1 of the Hindu Succession Act. They are inheriting that property. Then they can approach the revenue authorities if it is assessed to land revenue, agriculture land, for partition of it. That will be as per the share. Self-acquired property, there is no issue. Self-acquired property, only question which arises is whether that property has given to someone only or not. If this is not has been given to particular person by any instrument of testamentary document, then it is to be go to the all the co-sharers, sorry, all the heirs as per class 1 of the Hindu Succession Act. And they can file application for partition.
Yes, sir. These were the questions, sir. Thank you for sharing your knowledge. Now, as we had requested earlier, can you just give a brief overview in Punjabi also?
So far, this Punjabi is concerned, there is not an issue. I will give it. Firstly, I will give out the gair agriculture, gair खेतीबाड़ी ਜ਼ਮੀਨ, ਜਿਸ ਉੱਤੇ ਕੋਈ ਫਸਲ ਨਹੀਂ ਬੀਜੀ ਜਾਂਦੀ, ਉਹ ਜ਼ਮੀਨ ਨੂੰ ਗੈਰ ਖੇਤੀਬਾੜੀ ਕਿਹਾ ਜਾਂਦਾ ਹੈ। ਜਿਵੇਂ ਕਿ ਪਿੰਡ ਦੇ ਵਿੱਚ ਘਰ ਹੋਣਾ, ਸ਼ਹਿਰ ਦੇ ਵਿੱਚ ਘਰ ਹੋਣਾ, ਕੋਈ ਪਲਾਟ ਹੋਣਾ ਸ਼ਹਿਰ ਦੇ ਵਿੱਚ, ਇਹ ਸਾਰੇ ਗੈਰ ਖੇਤੀਬਾੜੀ ਦੇ ਵਿੱਚ ਆਉਂਦੇ ਹਨ, ਜਿਨ੍ਹਾਂ ਦੇ ਅੱਗੇ ਗੈਰ ਮੁਮਕਿਨ ਲਿਖਿਆ ਜਾਂਦਾ ਹੈ। ਗੈਰ ਮੁਮਕਿਨ ਪ੍ਰੋਪਰਟੀ ਦਾ ਤਰੀਕਾ ਇਹ ਹੈ ਕਿ ਵੀ ਤੁਹਾਨੂੰ ਸਿਵਲ ਕੋਰਟ ਜਾਣਾ ਪੈਂਦਾ ਹੈ, ਦੁਕਾਨਾਂ ਨੂੰ ਕਿਸੇ ਦੀਆਂ, ਕਿਸੇ ਦਾ ਘਰ ਹੈ ਵੰਡਣਾ ਪੈਂਦਾ ਹੈ। ਉਹਦੇ ਬਾਰੇ ਇਹ ਕਾਨੂੰਨ ਇਹ ਹੈ ਜਿਹੜਾ ਕਿ ਤਕਸੀਮ ਦਾ ਐਕਟ ਹੈ 1893 ਦਾ, ਉਹ ਲਾਗੂ ਹੁੰਦਾ ਹੈ। ਉਸ ਦੇ ਵਿੱਚ ਜੇ ਉਹ ਇੱਕ, ਮੈਂ ਜਿਵੇਂ ਦੁਕਾਨ ਦੀ ਦੱਸਿਆ ਸੀ 9x10 ਫੁੱਟ ਦੀ ਦੁਕਾਨ ਹੈ, 5 ਭਾਈਆਂ 'ਚ ਵੰਡਣੀ ਹੈ, ਤਾਂ ਉਹ ਕਿਵੇਂ ਵੰਡੀ ਜਾਊਗੀ? ਉਹਦੇ ਲਈ ਸਿਵਲ ਸੂਟ ਫਾਈਲ ਕੀਤਾ ਜਾਊਗਾ, ਮਤਲਬ ਦਾਵਾ ਦੀਵਾਨੀ ਅਦਾਲਤ ਦੇ ਵਿੱਚ ਦੀਵਾਨੀ ਦਾਵਾ ਫਾਈਲ ਕੀਤਾ ਜਾਊਗਾ ਕਿ ਵੀ ਮੇਰਾ ਇਹ 'ਚ ਹਿੱਸਾ ਹੈ, ਆ ਮੇਰਾ ਰਾਈਟ ਹੈ ਤੇ ਮੈਨੂੰ ਇਸ ਤਰ੍ਹਾਂ ਜ਼ਮੀਨ ਮੇਰਾ ਇੰਨਾ ਮਿਲਣਾ ਚਾਹੁੰਦਾ ਹੈ। ਉਹਦੇ ਵਿੱਚ ਸੈਕਸ਼ਨ 2 ਦੇ ਵਿੱਚ ਲਿਖਿਆ ਹੋਇਆ ਹੈ ਕਿ ਵੀ ਕੋਰਟ ਜੇ ਕਹੇ ਕਿ ਵੀ ਇਹ ਜਿਹੜੀ ਪਰਪਜੀ ਸਰਵ ਨਹੀਂ ਹੋਣਾ ਦੇ ਕੇ ਇੱਕ ਫੁੱਟ ਦੇ ਨਾਲ, ਨਾ ਤਾਂ ਕੰਧ ਵੀ ਨਹੀਂ ਨਿਕਲਣੀ, ਉਸ ਸਿਚੁਏਸ਼ਨ ਦੇ ਵਿੱਚ ਤਾਂ ਕੋਰਟ ਉਸ ਨੂੰ ਕਹਿ ਸਕਦੀ ਹੈ ਵੀ ਇਹ ਪ੍ਰਾਪਰਟੀ ਨੂੰ ਸੇਲ ਕਰਕੇ ਜਿੰਨੇ ਕੁ ਪੈਸੇ ਆਉਣਗੇ ਉਹ ਸਾਰਿਆਂ ਦੇ ਸ਼ੇਅਰ ਮੁਤਾਬਕ ਵੰਡ ਦਿੱਤੇ ਨੇ। ਇੱਕ ਤਰੀਕਾ ਤਾਂ ਇਹ ਹੈ। ਜਦੋਂ ਸਿਵਲ ਸੂਟ ਫਾਈਲ ਕੀਤਾ ਜਾਂਦਾ ਹੈ, ਮੈਂ ਇਸ ਗੱਲ ਤੋਂ ਪਹਿਲਾਂ ਦੱਸਣ ਵਾਸਤੇ ਇਹ ਦੱਸਣਾ ਸੀ ਕਿ ਇੱਕ ਤਾਂ ਮੁੱਢਲੀ ਡਿਗਰੀ ਪਾਸ ਹੁੰਦੀ ਹੈ, ਇੱਕ ਆਖਰੀ ਡਿਗਰੀ ਪਾਸ ਹੁੰਦੀ ਹੈ, ਫਾਈਨਲ ਡਿਗਰੀ। ਜਿਹੜੀ ਮੁੱਢਲੀ ਡਿਗਰੀ ਦੇ ਵਿੱਚ ਹਿੱਸੇ ਡਿਟਰਮਿਨ ਕੀਤੇ ਜਾਂਦੇ, ਤੁਹਾਡਾ ਕਿੰਨਾ ਹੱਕ ਹੈ, ਤੁਹਾਡਾ ਕਿੰਨਾ ਸ਼ੇਅਰ ਹੈ, ਉਹ ਫੈਸਲਾ ਕੀਤਾ ਜਾਂਦਾ ਹੈ। ਉਸ ਤੋਂ ਬਾਅਦ ਜਿਹੜੀ ਹੈ ਵੀ ਉਹਨੂੰ ਜੇ ਉਹ ਪਾਰਟ ਜ਼ਮੀਨ ਨੂੰ ਵੰਡਿਆ ਜਾ ਸਕਦਾ, ਉਹ ਥਾਂ ਨੂੰ ਵੰਡਿਆ ਜਾ ਸਕਦਾ, ਤਾਂ ਉਹ ਦਿੱਤੀ ਜਾਂਦੀ ਹੈ ਜਿੰਨਾ ਜਿੰਨਾ ਉਹਦਾ ਹਿੱਸਾ ਹੁੰਦਾ। ਜੇ ਵੱਡਾ ਹਿੱਸਾ ਹੋਵੇ ਤਾਂ ਉਹਦੇ ਹਿੱਸੇ ਮੁਤਾਬਕ ਜਿੰਨਾ ਕੁ ਬਣਦਾ ਉਹਨੂੰ ਦੇ ਦਿੱਤਾ ਜਾਂਦਾ। ਦੂਸਰੀ ਗੱਲ ਮੈਂ ਸੈਕਸ਼ਨ 2 ਥੱਲੇ ਦੱਸੀ ਸੀ ਕਿ ਵੀ ਇਹ ਵੇਚੀ ਜਾ ਸਕਦੀ ਹੈ ਤੇ ਜਿੰਨੇ ਕੁ ਪੈਸੇ ਆਉਣਗੇ ਉਹ ਸ਼ੇਅਰ ਮੁਤਾਬਕ ਵੰਡ ਦਿੱਤੇ ਜਾਣਗੇ। ਉੱਥੇ ਇੱਕ ਇਹ ਵੀ ਹੋ ਸਕਦਾ ਜਿਹੜਾ ਸੈਕਸ਼ਨ 3 ਕਹਿੰਦਾ ਕਿ ਵੀ ਜੇ ਕੋਈ ਹਿੱਸੇਦਾਰ ਉਹ ਜ਼ਮੀਨ ਖਰੀਦਣਾ ਚਾਹੁੰਦਾ ਹੈ ਤਾਂ ਉਹ ਆਪਣਾ ਕਹਿ ਸਕਦਾ ਕਿ ਵੀ ਮੈਂ ਖਰੀਦਣੀ ਹੈ, ਤੇ ਕੋਰਟ ਦੇ ਵਿੱਚ ਉਹਦੇ ਵਿੱਚ ਵੀ ਪ੍ਰੋਸੀਜਰ ਦਿੱਤਾ ਹੈ ਵੀ ਉਹਦੀ ਕਿਵੇਂ ਰਿਜ਼ਰਵ ਪ੍ਰਾਈਸ ਕਰਦੀ ਹੈ, ਕਿਵੇਂ ਉਹ ਹਿੱਸੇਦਾਰ ਆਪਣੀ ਉਹਦੀ ਬੋਲੀ ਦੇਣਗੇ ਤੇ ਕਿੰਨਾ ਪੈਸਾ ਉਹ ਕਿਵੇਂ ਦੇਣਗੇ। ਕਿਉਂਕਿ ਇਹ ਸਿਚੁਏਸ਼ਨ ਦੇ ਵਿੱਚ ਦੋ ਗੱਲਾਂ ਹੋ ਗਈਆਂ। ਇੱਕ ਤਾਂ ਜ਼ਮੀਨ ਮੈਨੂੰ ਹਿੱਸੇਦਾਰ ਜਿਹੜੇ ਹਿੱਸੇਦਾਰ ਹੈ ਉਹਨਾਂ ਨੂੰ ਆਪਣੇ ਹਿੱਸੇ ਦੀ ਆਉਂਦੀ ਹੈ। ਜਿਹੜਾ ਡਿਸਪਿਊਟ ਹੈ ਉਹ ਦੂਜੇ ਹਿੱਸੇਦਾਰਾਂ ਦਾ, ਜਿਹੜਾ ਨਹੀਂ ਰੱਖਣਾ ਚਾਹੁੰਦੇ ਉਹ ਉਸ ਨੂੰ ਵੇਚ ਸਕਦੇ। ਵੇਚ ਕਿਵੇਂ ਸਕਦੇ ਨੇ? ਮਤਲਬ ਬੋਰਡ ਮੇ ਲੈ ਸਕਦੇ ਆ, ਖਰੀਦ ਸਕਦੇ ਆ। ਉਹ ਕੋਰਟ ਰਿਜ਼ਰਵ ਪ੍ਰਾਈਸ ਫਿਕਸ ਕਰਦੀ ਹੈ ਕਿ ਵੀ ਇੰਨੀ ਕੁ ਪ੍ਰਾਈਸ ਹੈ, ਤੇ ਉਸ ਤੋਂ ਬਾਅਦ ਜਿਹੜੀ ਵੱਧ ਬੋਲੀ ਦੇਣ ਵਾਲਾ ਹੈ ਉਹ ਲੈ ਸਕਦਾ ਉਸਨੂੰ। ਇਹ ਕੀਤਾ, ਇਸ ਦਾ ਤਰੀਕਾ ਹੈਗਾ। ਜੇ ਨਹੀਂ ਹੈਗੀ, ਕਿਸੇ ਨੇ ਆਪਣਾ ਹਿੱਸਾ ਕਿਸੇ ਨੂੰ ਪਹਿਲਾਂ ਹੀ ਟ੍ਰਾਂਸਫਰ ਕਰਤਾ, ਆਪਣਾ ਹਿੱਸੇ ਦੀ ਰਜਿਸਟਰੀ ਕਰਾਤੀ, ਤਾਂ ਟ੍ਰਾਂਸਫਰੀ ਦਾ ਵੀ ਇਹੀ ਰਾਈਟ ਹੈ। ਉਹ ਖਰੀਦ ਵੀ ਸਕਦਾ ਹੈ ਤੇ ਦੇ ਵੀ ਸਕਦਾ ਹੈ। ਅਲਟੀਮੇਟਲੀ ਜਿਹਦਾ ਲੈਸਰ ਸ਼ੇਅਰ ਹੁੰਦਾ ਉਹਦੀ ਟੈਂਡੈਂਸੀ ਹੁੰਦੀ ਹੈ ਕਿ ਮੈਂ ਖਰੀਦਾਂ ਨਾ, ਮੈਂ ਵੇਚ ਹੀ ਦੇਵਾਂ ਆਪਦਾ ਹਿੱਸਾ। ਇਹ ਸਿੰਪਲ ਤਰੀਕਾ ਤਾਂ ਹੈਗਾ ਗੈਰ ਐਗਰੀਕਲਚਰ ਦਾ। ਜਿਹੜੀ ਐਗਰੀਕਲਚਰ ਹੈ ਉਹਦੇ ਲਈ ਤੁਹਾਨੂੰ ਪਟਵਾਰੀ ਦੇ ਕੋਲੇ ਜਾ ਕੇ ਫਰਦ ਤੇ ਜਮਾਬੰਦੀ ਲੈਣੀ ਪੈਂਦੀ ਹੈ, ਜਿਹੜੀ ਲੇਟੈਸਟ ਹੋਵੇ, ਜਿਹੜੀ ਹਾਲੀਆ ਚੱਲ ਰਹੀ ਹੋਵੇ। ਉਸ ਦੇ ਬੇਸ ਦੇ ਉੱਤੇ ਲਿਆ ਕੇ ਤੁਸੀਂ ਏਸੀ ਫਸਟ ਗ੍ਰੇਡ ਜਿਹੜੀਆਂ ਕਿ ਤਹਿਸੀਲਦਾਰ ਤੇ ਨਾਇਬ ਤਹਿਸੀਲਦਾਰ ਨੂੰ ਪਾਵਰਾਂ ਦਿੱਤੀਆਂ ਗਈਆਂ ਹੋਈਆਂ ਏਸੀ ਫਸਟ ਗ੍ਰੇਡ ਦੀਆਂ, ਉਹਨਾਂ ਕੋਲੇ ਫਾਈਲ ਕਰ ਦਿਓ। ਐਪਲੀਕੇਸ਼ਨ ਫਾਈਲ ਕੀਤੀ ਜਾਂਦੀ ਹੈ, ਆਪ ਫਾਈਲ ਕਰ ਦਿਓ, ਚਾਹੇ ਥਰੂ ਵਕੀਲ ਸਾਹਿਬ ਦੇ ਥਰੂ ਕਰ ਦਿਓ। ਉਹ ਤੁਹਾਡੀ ਦੇਖ ਕੇ ਕਿ ਵੀ ਇਹ ਹੋਣ ਦੇ ਕਾਬਲ ਹੈ ਤੇ ਜ਼ਮੀਨ ਐਗਰੀਕਲਚਰ ਹੈ, ਅਸੈਸ ਟੂ ਲੈਂਡ ਰੈਵਨਿਊ ਹੈ, ਮਤਲਬ ਮਾਲੀਏ ਨੂੰ ਅਸੈਸ ਕੀ ਹੈਗੀ, ਇਸ ਦੇ ਉੱਤੇ ਫਿਕਸ ਹੈ, ਤਾਂ ਉਹ ਪਾਰਟੀਸ਼ਨ ਸ਼ੁਰੂ ਕਰੇਗਾ। ਪਾਰਟੀਸ਼ਨ ਸ਼ੁਰੂ ਕਰਕੇ ਦੂਜੀ ਪਾਰਟੀ ਨੂੰ ਨੋਟਿਸ ਦੇਵੇਗਾ, ਪਾਰਟੀ ਪੇਸ਼ ਹੋਵੇਗੀ, ਉਹ ਆਪਣਾ ਜਵਾਬ ਦੇਣਗੀਆਂ। ਜਵਾਬ ਦੇਣ ਦੇ ਵਿੱਚ ਕਈ ਵਾਰ ਜਿਹੜਾ ਹੈ ਕਿ ਹਿੱਸਿਆਂ ਦੇ ਬਾਰੇ ਕੋਈ ਕੁਐਸਚਨ ਆਫ ਟਾਈਟਲ ਜਿਹਨੂੰ ਕਹਿੰਦੇ ਆ, ਉਹ ਪੈਦਾ ਕਰ ਦਿੰਦੇ ਆ ਕਿ ਵੀ ਇਹ ਪਾਰਟੀਸ਼ਨ ਨਹੀਂ ਹੋ ਸਕਦੀ, ਪਹਿਲਾਂ ਇਹ ਗੱਲ ਦਾ ਡਿਸਾਈਡ ਕਰੋ। ਤਾਂ ਏਸੀ ਨੂੰ 2 ਪਾਵਰਸ ਹੈ। ਉਹ ਇਹ ਕਹਿ ਸਕਦਾ ਕਿ ਵੀ ਮੈਂ ਨਹੀਂ ਪ੍ਰੋਸੀਡ ਕਰੂੰਗਾ, ਸਿਵਲ ਕੋਰਟ ਤੋਂ ਡਿਸਾਈਡ ਕਰਾਓ ਇਹਦੇ ਜਿਹੜੇ ਗੁੰਝਲਦਾਰ ਹਿੱਸੇ ਹੈ, ਪਾਵਰ ਜਿਹੜੀ ਹੈਗੀ ਤੁਹਾਡੀ ਬਣਦਾ ਨਹੀਂ ਜਾਂ ਨਹੀਂ ਬਣਦਾ, ਜਾਂ ਰਿਕਾਰਡ ਗਲਤ ਹੈ, ਉਸ ਬਾਰੇ ਡਿਟਰਮਿਨ ਤੁਸੀਂ ਸਿਵਲ ਕੋਰਟ ਤੋਂ ਜਾ ਕੇ ਕਰਾਉਣਾ ਹੈ, ਜਾਂ ਉਹ ਖੁਦ ਸਿਵਲ ਕੋਰਟ ਦੀ ਪਾਵਰ ਐਕਸਰਸਾਈਜ਼ ਕਰਕੇ ਉਹ ਜਿਹੜਾ ਕੁਐਸਚਨ ਆਫ ਟਾਈਟਲ ਨੂੰ ਡਿਸਾਈਡ ਕਰ ਸਕਦਾ। ਚਲੋ, ਜੇ ਉਹ ਸਾਰਾ ਕੁਝ ਹੋਣ ਤੋਂ ਬਾਅਦ ਉਹ ਪ੍ਰੋਸੀਡ ਕਰਦਾ ਹੈ ਤਾਂ ਉਹ ਫਿਰ ਨਕਸ਼ਾ ਅਲਫਕਾਲ ਕਰਦਾ ਹੈ, ਜਿਹੜਾ ਕਿ ਜਿਹਨੂੰ ਊੜਾ ਵੀ ਕਹਿ ਦਿੰਦੇ ਆ, ਫਿਰ ਉਹਦੇ ਵਿੱਚ ਜਿੰਨੇ ਹੈਗੇ ਤੁਹਾਡੇ ਸ਼ੇਅਰ ਦੱਸਿਆ ਜਾਂਦਾ ਹੈ, ਤੁਹਾਡੀ ਪ੍ਰਾਪਰਟੀ, ਤੁਹਾਡੇ ਕੋਲੇ ਕਬਜ਼ਾ ਕਿੰਨੇ ਨੇ, ਤੁਹਾਡੇ ਕੋਲੇ ਘੱਟ ਵੱਧ ਹੈ ਕਿ ਘੱਟ ਹੈ, ਉਹ ਸਾਰੀਆਂ ਚੀਜ਼ਾਂ ਉਹਦੇ ਚ ਮੈਂਸ਼ਨ ਕੀਤੀਆਂ ਜਾਂਦੀਆਂ। ਤੁਸੀਂ ਉਹਨੂੰ ਐਗਜ਼ਾਮਿਨ ਕਰਨਾ। ਜੇ ਤੁਹਾਨੂੰ ਲੱਗਦਾ ਕਿ ਉਹ ਚ ਪ੍ਰੋਪਰ ਨਹੀਂ ਲਿਆਇਆ ਤਾਂ ਤੁਸੀਂ ਉਹਤੇ ਇਤਰਾਜ਼ ਦੇ ਸਕਦੇ ਹੋ। ਉਸ ਤੋਂ ਬਾਅਦ ਜਦੋਂ ਨਕਸ਼ਾ ਹਲਫ ਆ ਜਾਂਦਾ, ਫਿਰ ਪਾਰਟੀਆਂ ਦਾ ਕੋਈ ਕਿਸੇ ਦਾ ਇਤਰਾਜ਼ ਨਹੀਂ ਹੁੰਦਾ, ਤਾਂ ਉਸ ਦੇ ਉੱਤੇ ਬਿਆਨ ਲਿਖੇ ਜਾਂਦੇ ਆ ਪਾਰਟੀ ਨੂੰ ਵੀ ਤਕਸੀਮ ਕਿਵੇਂ ਕੀਤੀ ਜਾਵੇ, ਚੰਗੀ ਚੋਂ ਚੰਗੀ, ਮਾੜੀ ਚੋਂ ਮਾੜੀ, ਕੀਮਤ ਦੇ ਹਿਸਾਬ ਨਾਲ, ਖਾਲ ਪਈਆਂ ਸਾਂਝੇ ਰੱਖ ਕੇ, ਤੇ ਜਿਹੜੀ ਮੇਰਾ ਟਿਊਬਵੈਲ ਲੱਗਿਆ ਉਹ ਮੈਨੂੰ ਦਿੱਤੀ ਜਾਵੇ। ਉਸ ਤਰ੍ਹਾਂ ਸਾਰੇ ਸਿਚੁਏਸ਼ਨ ਲਿਖੀ ਜਾਂਦੀ ਹੈ ਮੌਕੇ ਦੇ ਮੁਤਾਬਕ। ਕਿਸਮ ਵਾਈਜ਼ ਵੀ ਸੜਕ ਤੇ ਲੱਗਦੀ ਕੀਮਤੀ ਜ਼ਮੀਨ ਹੈ, ਉਹਨੂੰ ਇਸ ਤਰ੍ਹਾਂ ਦਿੱਤਾ ਜਾਵੇ, ਦੂਸਰੇ ਜ਼ਮੀਨ ਇਸ ਤਰ੍ਹਾਂ ਦੀ ਹੈ, ਉਹਨੂੰ ਇਸ ਤਰ੍ਹਾਂ ਕੀਤਾ ਜਾਵੇ, ਉਹ ਸਾਰਾ ਉਹਦੇ ਚ ਕੀਤਾ ਜਾਂਦਾ ਹੈ। ਉਸ ਤੋਂ ਬਾਅਦ ਜਦੋਂ ਤਰੀਕਾ ਤਕਸੀਮ ਜਿਹਨੂੰ ਪਸੰਦ ਨਹੀਂ ਆਉਂਦਾ, ਉਹਦੀ ਵੀ ਅਪੀਲ ਹੋ ਸਕਦੀ ਹੈ। ਅਪੀਲ ਰਿਵੀਜ਼ਨ ਹਾਈ ਕੋਰਟ ਤੱਕ ਤੁਸੀਂ ਆ ਸਕਦੇ ਹੋ ਕਿ ਵੀ ਇਹ ਠੀਕ ਨਹੀਂ ਬਣਾਇਆ, ਫੇਵਰਕ ਹੋਇਆ, ਪਾਰਟਿਕੂਲਰਾਈਜ਼ ਇਹ ਨਹੀਂ ਹੋਇਆ, ਸਾਡੀ ਸਟੇਟਮੈਂਟ ਸੀ ਜੇ ਸੀ, ਸਾਰਾ ਕੁਝ ਉਸ ਦੇ ਬੇਸ ਤੇ ਉੱਤੇ ਹੋ ਸਕਦਾ ਹੈ। ਉਸ ਤੋਂ ਬਾਅਦ ਨਕਸ਼ਾ ਬੇ ਆਉਂਦਾ, ਆੜਾ ਨਕਸ਼ਾ ਵੀ ਕਹਿ ਦਿੰਦੇ ਨੇ। ਉਹਦੇ ਚ ਤੁਹਾਡੇ ਜਿਹੜੇ ਮੋਡ ਆਫ ਪਾਰਟੀਸ਼ਨ ਦੇ ਮੁਤਾਬਕ ਤੁਹਾਡੇ ਕੁਰੇ ਬਣਦੇ, ਸੈਪਰੇਟ ਜ਼ਮੀਨ ਲੱਗਦੇ, ਉਹਦੇ ਖਾਲ ਪਈਆਂ ਲਾਏ ਜਾਂਦੇ ਆ ਤੇ ਤੁਹਾਨੂੰ ਜ਼ਮੀਨ ਪਾਈ ਜਾਂਦੀ ਹੈ। ਘਾਟਾ ਵਾਧਾ ਜ਼ਮੀਨ ਤੁਹਾਡੇ ਹਿੱਸੇ ਮੁਤਾਬਕ ਖਾਲਾਂ ਤੇ ਪਈਆਂ ਚੋਂ ਕੱਟੀ ਜਾਂਦੀ ਹੈ, ਬਾਕੀ ਜ਼ਮੀਨ ਤੁਹਾਨੂੰ ਡਿਫਾਈਨ ਕਰਕੇ ਰਸਤਿਆਂ ਦੇ ਉੱਤੇ ਲੱਗਦੇ ਪਈਆਂ। ਮੇਨ ਰਸਤੇ ਆਲਰੇਡੀ ਐਗਜ਼ਿਸਟ ਕਰਦੇ, ਹੁਣ ਨਿਆਈ ਦੇ ਨੇੜੇ ਜ਼ਮੀਨ ਹੈ ਉਹ ਬਰਾਬਰ ਦੀ ਜ਼ਮੀਨ ਉੱਥੇ ਮਿਲਦੀ ਹੈ। ਜਿਹੜੀ ਮੇਨ ਮੈਟਲ ਸੜਕ ਹੈ, ਪੱਕੀ ਸੜਕ ਜਿਹਨੂੰ ਕਹਿੰਦੇ ਆ ਆਪਾਂ, ਉਹਦੇ ਉੱਤੇ ਵੀ ਮਿਲਦਾ ਜਿੰਨਾ ਸ਼ੇਅਰ ਉਸ ਨੂੰ ਦਿੱਤਾ ਜਾ ਦਿੰਦਾ, ਜੋ ਵੀ ਉਹਦਾ ਸ਼ੇਅਰ ਹੁੰਦਾ। ਬਾਕੀ ਜ਼ਮੀਨ ਦੂਸਰੇ ਥਾਵਾਂ ਤੇ ਉਵੇਂ ਇੱਕ ਵੰਡ ਦਿੱਤੀ ਜਾਂਦੀ ਹੈ, ਪਿੰਡ ਦੇ ਨੇੜੇ, ਪਿੰਡ ਤੋਂ ਦੂਰ। ਇਹ ਸਾਰੀਆਂ ਗੱਲਾਂ ਧਿਆਨ ਚ ਰੱਖਦੇ ਹੋਏ ਕੀਮਤ ਦੇ ਹਿਸਾਬ ਨਾਲ ਜਿਹਨੂੰ ਚੰਗੀ ਤੋਂ ਚੰਗੀ, ਮਾੜੀ ਤੋਂ ਮਾੜੀ ਜ਼ਮੀਨ ਵੰਡੀ ਜਾਂਦੀ ਹੈ। ਤੇ ਜਦੋਂ ਇਹ ਜ਼ਮੀਨ ਵੰਡੀ ਜਾਂਦੀ ਹੈ ਤਾਂ ਤੁਹਾਡੇ ਇਹਦੇ ਨਾਲ ਇੱਕ ਫੀਲਡ ਬੁੱਕ ਤਿਆਰ ਹੁੰਦੀ ਹੈ, ਉਹ ਵੀ ਨਾਲ ਲੱਗੀ ਹੁੰਦੀ ਹੈ। ਤੇ ਜੇ ਕੋਈ ਨੰਬਰ ਪਾਰਟੀਸ਼ਨ ਹੋਇਆ ਕਿੱਲਾ ਨੰਬਰ, ਤਾਂ ਉਹਦਾ ਨੰਬਰ ਉਹਨੂੰ ਅਸਾਈਨ ਕੀਤਾ ਜਾਂਦਾ। 12 ਜਿਵੇਂ 12 ਨੰਬਰ ਕਿੱਲਾ ਹੈ, ਉਹਨੂੰ 4-5 ਹਿੱਸਿਆਂ ਦਿੱਤਾ, 12/1, 2, 3, 12/2, 12/3, 12/4 ਲਿਖ ਕੇ ਉਹ ਦੱਸਿਆ ਜਾਂਦਾ ਵੀ ਕਿਹੜੀ ਸਾਈਡ ਕਿਹਨੂੰ ਆਇਆ, ਕਿਵੇਂ ਆਇਆ। ਆਮ ਤੌਰ ਤੇ ਨਕਸ਼ਾ ਬੇ ਦੇ ਵਿੱਚ ਪਾਰਟੀਆਂ ਦੇ ਰੰਗ ਦਿਖਾਏ ਜਾਂਦੇ ਹਨ। ਇੱਕ ਪਾਰਟੀ ਨੂੰ ਲਾਲ ਰੰਗ, ਦੂਜੇ ਨੂੰ ਨੀਲਾ ਰੰਗ, ਹਰਾ ਰੰਗ, ਪੀਲਾ ਰੰਗ, ਬਟ ਜਿੰਨੀਆਂ ਕੁ ਨੰਬਰ ਪਾਰਟੀਆਂ ਉਸ ਰੰਗਾਂ ਨਾਲ ਵੱਖਰੇ ਵੱਖਰੇ ਰੂਪ ਦੇ ਵਿੱਚ ਦਿਖਾਇਆ ਜਾਂਦਾ ਤਾਂ ਕਿ ਉਹਨਾਂ ਨੂੰ ਪੋਜੀਸ਼ਨ ਕਲੀਅਰ ਹੋ ਸਕੇ। ਜਦੋਂ ਉਸ ਤੋਂ ਨਕਸ਼ਾ ਬੇ ਦੇ ਉੱਤੇ ਵੀ ਅਪੀਲਾਂ ਦਲੀਲਾਂ ਹੈਗੀਆਂ, ਜੇ ਤੁਹਾਨੂੰ ਨਹੀਂ ਪਸੰਦ ਕਿ ਵੀ ਇਹ ਗਲਤ ਹੋਇਆ, ਜੇ ਹੋਇਆ, ਉਸ ਦਾ ਅਪੀਲ ਦਲੀਲ ਤੁਸੀਂ ਕਰ ਸਕਦੇ ਹੋ, ਜਿਹੜੀਆਂ ਕਿ ਕਲੈਕਟਰ, ਕਮਿਸ਼ਨਰ, ਫਾਈਨੈਂਸ਼ੀਅਲ ਕਮਿਸ਼ਨਰ ਤੇ ਹਾਈ ਕੋਰਟ ਤੱਕ, ਸੁਪਰੀਮ ਕੋਰਟ ਤੱਕ ਜਾ ਸਕਦੀਆਂ। ਇਹ ਤੁਹਾਡੇ ਤੇ ਡਿਪੈਂਡ ਕਰਦਾ। ਫਿਰ ਉਸ ਤੋਂ ਬਾਅਦ ਨਕਸ਼ਾ ਈਡੀ ਆਉਂਦਾ, ਜਿਹਨੂੰ ਨਕਸ਼ਾ ਜੀਮ ਵੀ ਕਹਿੰਦੇ ਨੇ। ਜਦੋਂ ਨਕਸ਼ਾ ਬੇ ਫਾਈਨਲ ਹੋ ਜਾਂਦਾ, ਉਹਦੀ ਅਪਰੂਵਲ ਤੋਂ ਬਾਅਦ ਨਕਸ਼ਾ ਜੀਮ ਬਣਦਾ, ਜਿਹਦੇ ਚ ਪੁਰਾਣੀ ਸਿਚੁਏਸ਼ਨ ਵੀ ਦਿਖਾਈ ਜਾਂਦੀ ਹੈ ਤੇ ਤਕਸੀਮ ਹੋਣ ਤੋਂ ਬਾਅਦ ਦੀ ਸਿਚੁਏਸ਼ਨ ਵੀ ਦਿਖਾਈ ਜਾਂਦੀ ਹੈ। ਉਹ ਉਸ ਤੋਂ 30 ਦਿਨਾਂ ਬਾਅਦ ਫਿਰ ਇੱਕ ਨਕਸ਼ਾ ਜਿਹੜਾ ਹੈਗਾ ਇੰਸਟਰੂਮੈਂਟ ਆਫ ਸਨਅਤ ਤਕਸੀਮ ਬਣਦੀ ਹੈ, ਜਿਹੜਾ ਕਿ ਵਰਚੁਅਲੀ ਨਕਸ਼ਾ ਜੀਨ ਦੀ ਰੀਪਰੋਡਕਸ਼ਨ ਹੁੰਦੀ ਹੈ, ਪਰ ਉਹਦੇ ਮੂਹਰੇ ਲਿਖਿਆ ਜਾਂਦਾ ਵੀ ਕਬਜ਼ਾ ਕਦੋਂ ਮਿਲੂਗਾ, ਕਿਵੇਂ ਮਿਲੂਗਾ, ਫਸਲ ਕੱਟਣ ਤੋਂ ਬਾਅਦ, ਫਲਾਣੇ ਤੋਂ ਪਰਟੀਕੂਲਰ ਸੌਣੀ ਹਾੜੀ ਜੋ ਵੀ ਸਿਚੁਏਸ਼ਨ ਹੈ ਉਸ ਦੇ ਮੁਤਾਬਕ ਉਹਦੇ ਚ ਲਿਖਿਆ ਜਾਂਦਾ ਹੈ। ਜਦੋਂ ਇਹ ਸਾਰਾ ਕੁਝ ਫਾਈਨਲ ਹੋ ਜਾਂਦਾ ਹੈ ਤਾਂ ਪਾਰਟੀਆਂ ਜਿਹੜੀਆਂ ਹੈਗੀਆਂ ਉਸ ਨੂੰ, ਤਹਿਸੀਲਦਾਰ ਨੂੰ ਕਹਿ ਸਕਦੀਆਂ ਵੀ ਸਾਨੂੰ ਇਹਦੇ ਐਕਚੁਅਲ ਕਬਜ਼ੇ ਦਵਾਏ ਜਾਣ, ਉਹ ਉਸ ਦੇ ਮੁਤਾਬਕ ਕਬਜ਼ੇ ਦਿੱਤੇ ਜਾਂਦੇ ਆ ਪਾਰਟੀਆਂ ਤੇ, ਤਾਂ ਜਿਹੜੀ ਤਕਸੀਮ ਹੈ ਉਹ ਫਾਈਨਲ ਹੋ ਜਾਂਦੀ। ਹੋਰ ਦੱਸੋ ਜੀ, ਐਨੀ ਕੋਈ ਕੁਐਸਚਨ, ਐਨੀਥਿੰਗ?
Sir, बस यही क्वेश्चन थी। English we have already answered, and thank you for sharing your knowledge. Stay blessed always. Thank you everyone. Stay safe, stay blessed.